Okay, let's dive in. Today, we're exploring a concept that, well, it feels fundamental to the United States, but it's surprisingly complex and fiercely debated: birthright citizenship. It's all about how someone becomes a U.S. citizen, simply by being born here.
That's right. And at its core, U.S. citizenship can be acquired in two main ways. There's just soli, which
Mm.
means right of the soil, basically, being born within U.S. territory. Or there's just sanguinis, right of blood, which is because, at least one parent was a U.S. citizen. So our mission for this deep dive is to explore the current law, its deep historical roots, the landmark Supreme Court cases that have shaped it, and importantly, the significant modern political disputes that continue to challenge it.
Right, so you're going to get a shortcut to being truly well-informed on this, maybe with some surprising facts along the way. So let's start with the foundation. Where does birthright citizenship actually come from in U.S. law?
Okay, the bedrock really is the Citizenship Clause. It's part of the 14th Amendment to the Constitution, adopted way back on July 9th, 1868, and it states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
Hmm.
And this clause, it was actually a late addition to the amendment. It was specifically intended to make clear that even children born within U.S. jurisdiction, even if their parents were foreign nationals, were guaranteed citizenship.
Okay.
And ever since the Supreme Court's decision in United States v. Wong Kim Ark back in 1898, this clause has been, well, pretty widely understood to guarantee citizenship to basically all persons born in the U.S. and subject to the jurisdiction thereof.
And that phrase, subject to the jurisdiction thereof, what does that exclude traditionally?
Well, under common law, it traditionally excluded only a very narrow group,
Yeah.
children of foreign diplomats and soldiers of occupying foreign forces, pretty
Mhm.
specific cases.
Got it. So when we say born in the United States, what does that actually cover today? Is it just like land?
No, it's broader than just dry land. Under federal law, yeah, a person is a U.S. citizen if born in the United States and subject to its jurisdiction. And that includes children born in U.S. internal waters, territorial seas, even U.S. airspace.
Airspace too. Interesting.
Yep, and incorporated territories, like Palmyra Atoll, they also grant birthright citizenship automatically.
But I remember reading there's a distinction for unincorporated territories or outlying possessions. That seems like a key detail.
It absolutely is. That's a crucial difference. So, for example, people born in American Samoa, they're considered U.S. nationals, but they aren't automatically citizens at birth.
Okay, so nationals, not citizens. What's the practical difference there?
Well, it means they owe allegiance to the U.S. They can carry a U.S. passport, but they don't automatically get all the rights of citizenship, like voting in federal elections or easily moving between states without potentially needing further naturalization steps. And this distinction, it was upheld relatively recently by the D.C. Circuit Court in 2016 and the 10th Circuit in 2021, which actually reversed a lower court's ruling.
Okay, that makes sense. Now, what about the other path, the Des Sanguinis or right of blood citizenship through parentage? How has that evolved, especially for kids born overseas?
Right, that pathway has changed quite a bit over time. The first Naturalization Act back in 1790, it provided citizenship for children born overseas, but only if both parents were
For
citizens.
parents, okay.
Then in 1855, it was extended to children with citizen fathers and non-citizen mothers. And it wasn't until 1934 that it finally included children with citizen mothers and non-citizen fathers.
Wow, quite a delay for mothers.
Yeah, definitely reflects the times. And there also used to be these retention requirements. So if you were born abroad to just one U.S. citizen parent, you actually had to live in the U.S. for a certain amount of time to keep your citizenship.
Oh, really?
Yeah, but those were eventually eliminated retroactively in 1994.
Okay, so it sounds like there's still a lot of nuance there. Are there different rules today based on whether the parents are married or unmarried when the child's born overseas?
Yes, there's still an asymmetry, a difference, particularly for unmarried parents. It kind of reflects how these laws developed historically. So if both parents are U.S. citizens and married, the child is a citizen if either parent has simply resided in the U.S. at some point. Pretty straightforward.
Okay.
If one parent is a U.S. citizen and the other is a U.S. national, the citizen parent needs to have lived in the U.S. for a continuous period of at least 1 year before the child's birth.
1 year continuous. Got it.
And if one parent is a citizen and the other is not a citizen or national, then the U.S. citizen parent needs to meet stricter physical presence rules, basically, having lived in the U.S. for at least 5 years, 2 of those after age 14.
Okay, 5 years, 2 after 14. That's quite specific. And for unmarried parents.
That's where it gets even more distinct. Children born abroad to unmarried American mothers are generally citizens if the mother lived in the U.S. for a continuous year before the birth.
Okay, similar to the married national case.
Right. But for unmarried American fathers, it's tougher. Additional actions are required, like the father needs to agree to financial support or formally acknowledge paternity under oath or have paternity legally established by a court. And crucially, these actions have to happen while the child is still under 18.
So a real difference based on the parent's gender there.
Yes, and this distinction was actually upheld by the Supreme Court. You had Miller v. Albright in '98 and Nguyen v. INS in 2001. The court's reasoning back then mentioned concerns about, and this is the language used at the time, illegitimate Korean and Vietnamese children after wars. It really shows the historical context.
Yeah, definitely reflects older views.
Right.
Okay, shifting gears slightly, the president, there's that natural-born citizen requirement. Does the Constitution distinguish between being born here versus getting citizenship through parents for that?
That's a great question. The tricky part is the Constitution doesn't actually define natural born. So that lack of definition has led to, well, various controversies over the years. It doesn't explicitly say if there's a difference for the presidency based on just soli versus just sanguinis.
Huh. Okay, so this discussion about origins and definitions really makes you think about the deeper history. Where did this whole idea of birthright citizenship in the U.S. come from initially?
Well, it has really deep roots going back to English common law, which, the U.S. legal system inherited a lot from. A really key case was Calvin's case, way back in 1608 in England. It basically established that your status depended on where you were born. If you're born within the king's dominion, the legions, you owed allegiance to the king, and in return, you were entitled to the king's protection.
So allegiance tied to birthplace.
Exactly. And Justice Joseph Story, a famous American judge, put it really well in an 1830 case, Inglis v. Trustees of Sailor's Snug Harbor. He said basically every person who is born within the allegiance of a sovereign is a subject. And the exceptions were, as we mentioned, very narrow. Children of ambassadors, children of occupying enemy soldiers. That's it.
So this idea was pretty well established even before the Civil War in the early American legal system.
Oh, absolutely. You see it in early American legal writings, court cases like Lynch v. Clark in 1844. They held that anyone born in the U.S., it didn't matter if their parents were citizens or aliens, was considered a natural-born citizen. Chancellor James Kent, a really influential legal scholar back then, he framed it in a way that sounds very similar to the 14th Amendment we just talked about. He said, natives are all persons born within the jurisdiction of the United States.
Right.
And the Supreme Court itself, in that Wong Kim Ark case in 1898, called this rule ancient and fundamental.
But this ancient and fundamental rule, it wasn't applied universally, was it? I mean, thinking about the period before the Civil War,
Yeah.
Dred Scott.
You're absolutely right. That's the huge tragic asterisk. The Dred Scott v. Sanford decision in 1857, the Supreme Court, led by Chief Justice Caney, issued this just devastating ruling that African Americans, whether they were free or enslaved, could never be considered U.S. citizens.
Wow.
Yeah. And Justice Curtis, in his dissent, powerfully called it out as a, quote, skewed reading of history. He pointed out that free black men had actually been citizens with voting rights in 5 states when the country was founded under the Articles of Confederation.
So Dred Scott really exposed the deep contradictions.
It did, and it became this major catalyst. It forced a massive reckoning and led directly to huge legal changes after the Civil War. It fundamentally challenged who could belong in America.
So how did the law start to explicitly counter Dred Scott?
Well, even during the war in 1862, the Attorney General, Edward Bates, issued an opinion. He explicitly stated that the free man of color, if born in the United States, is a citizen. He argued that basically every person born in the country is, at the moment of birth, prima facie a citizen. That means, presumed to be a citizen unless proven otherwise.
Okay, so that set the stage.
It really did. That led directly to the Civil Rights Act of 1866. That act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, were citizens.
Right, the Indians not taxed exclusion, we need to come back to that.
We do. And then, of course, came the 14th Amendment in 1868, which took that principle from the Civil Rights Act and embedded it right into the Constitution, aiming to permanently overturn Dred Scott.
Now, this whole evolution of citizenship, it wasn't just about race. You mentioned earlier how it affected women's rights, often in ways that seem, well, quite shocking today.
Absolutely shocking. For a very long time, a married woman's citizenship status was generally tied completely to her husband's. It was called coverture. The Naturalization Act of 1804 kind of confirmed this. Then an 1855 act specified that a foreign woman married to a U.S. citizen could become a citizen, and children born abroad to citizen fathers were citizens, but only if they were white.
Only if they were white. Another major exclusion.
Exactly. And then it got even worse, arguably. The Expatriation Acts of 1868 and 1907, they actually codified that American women lost their U.S. citizenship automatically if they married a non-citizen.
Lost it automatically, just by getting married.
Yes, sometimes even retroactively without any notice. And the Supreme Court upheld this. In McKinsey v. Hare, 1915, the court said, essentially, that marrying a foreigner was like voluntarily giving up your citizenship.
That is just incredible to think about today. An American woman marrying someone from, say, France would just cease to be American.
Pretty much. And it got particularly problematic with laws like the Asian Exclusion Act of 1924. That act barred most people of Asian descent from immigrating or becoming naturalized citizens. So imagine an American-born woman marries an immigrant who was ineligible for citizenship under that act. She loses her U.S. citizenship, and then she could be legally considered a citizen of her husband's country, even if she'd never been there.
So she could become effectively stateless or trapped in a legal limbo.
Precisely. It created some truly awful situations.
So how did this finally start to change? What was the driving force?
Well, a big part of it was women gaining the right to vote with the 19th Amendment. Once women had more political power, they started pressuring Congress intensely.
Makes sense.
The Cable Act of 1922 was a really significant step. It guaranteed women independent citizenship if their spouse was eligible for naturalization. So it wasn't perfect. There were still limitations, especially tied to those race-based naturalization laws.
Right, so if she married someone ineligible, she might still lose citizenship.
Potentially, yes. The progress was gradual. Then the Equal Nationality Act of 1934 finally allowed American mothers to pass on citizenship to their children born abroad, the same right fathers had held for decades. But even that wasn't retroactive.
Still playing catch-up.
Right. The McCarran-Walter Act in 1952 aimed to remove more gender inequalities, replacing terms like husband or father with gender-neutral terms like spouse or parent in many parts of the nationality laws. Though, some differences in residency requirements for parents transmitting citizenship lingered and continued to evolve right up into the 1980s.
It's a long history. Now, let's go back to that phrase in the Civil Rights Act and the 14th Amendment, excluding Indians not taxed. What happened with Native Americans and birthright citizenship?
That's another really important and often overlooked part of the story. The Supreme Court addressed this directly in Elk v. Wilkins in 1884. The court ruled that Native Americans, specifically members of tribes recognized by the federal government, were not automatically citizens at birth under the 14th Amendment.
Why not? They were born here.
The court's reasoning was that being born in U.S. territory wasn't enough. They focused on the subject to the jurisdiction part. They argued that members of tribes owed allegiance to their tribal governments and were therefore not fully subject to the jurisdiction of the U.S. in the same way as others.
Another narrow interpretation of jurisdiction.
Exactly. It treated tribes as separate political entities in a way that denied individual citizenship. This was obviously a major barrier.
So how was that finally resolved?
It was resolved by Congress. The Indian Citizenship Act of 1924 finally granted citizenship unilaterally to all non-citizen Indians born within the territorial limits of the United States.
So 1924 is the key date there.
Yes. That act essentially made the Elk v. Wilkins decision obsolete and finally extended birthright citizenship across the board to Native Americans born within the U.S.
What a complex history, moving from these broad principles to specific, often discriminatory exclusions and then gradual, sometimes very slow inclusion. You mentioned Wong-Kim-Ark earlier as being really pivotal. Can we dig into that case a bit more? It sounds like it really cemented the modern understanding.
It really, really did. United States v. Wong-Kim-Ark, 1898. It's a cornerstone. The case was about Mr. Wong, who was born in San Francisco. His parents were Chinese citizens, subjects of the Emperor of China, but they were living and working in the U.S. as permanent residents. They weren't diplomats or anything like that.
Okay.
Wong-Kim-Ark traveled to China, and when he tried to return to the U.S., he was denied entry. The government argued he wasn't a citizen because his parents were Chinese subjects, even though he was born here. This was during the era of the Chinese Exclusion Acts, remember?
Right, a lot of anti-Chinese sentiment and laws.
Yes, exactly. So the Supreme Court had to decide, does the 14th Amendment's guarantee of citizenship for persons born in the United States and subject to its jurisdiction apply to the U.S.-born child of resident aliens whose country the U.S. might have tensions with? And the court's answer was a resounding yes. They held that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, end quote. They explicitly said this rule includes all children here born of resident aliens, end quote. The only exceptions they acknowledged were those very narrow common law ones. Children of foreign sovereigns, diplomats, or enemy soldiers on occupied territory.
So Wong Kim Ark basically said, if you're born here and your parents aren't diplomats or invading soldiers, you're a citizen, regardless of your parents' nationality or legal status as residents.
That's the general understanding and application of the ruling, yes. It firmly established that birth on U.S. soil is the primary basis for citizenship under the 14th Amendment for children of resident aliens.
And how has that principle held up over time? Have there been serious legal challenges to it?
Well, the core principle established in Wong Kim Ark has been remarkably resilient in the courts. For example, during World War II, in a 1943 case called Reagan v. King, there was an attempt to disenfranchise U.S. citizens of Japanese descent, basically arguing they weren't truly loyal.
Wow.
But the court dismissed that, specifically citing and upholding the precedent set in Wong Kim Ark. It reaffirmed that birthright citizenship granted under the 14th Amendment couldn't just be stripped away based on ancestry.
Okay, so that brings us to maybe the most contentious modern question. Does this principle, established in Wong Kim Ark, apply to children born in the U.S. today whose parents are undocumented immigrants?
That is the absolute core of the current debate. Now, the Supreme Court hasn't ruled directly on a case identical to Wong Kim Ark, but specifically involving parents who are undocumented.
Right, Wong Kim Ark's parents were lawful permanent residents, if I recall.
They were lawfully domiciled residents, yes. However, the reasoning in Wong Kim Ark focused broadly on being born and subject to the jurisdiction. And another key case, Plyler v. Doe from 1982, is really important here.
What did Plyler decide?
Plyler was about whether states could deny public education to undocumented children. The court ruled they couldn't, under the Equal Protection Clause of the 14th Amendment. And crucially, in reaching that decision, the court reasoned that undocumented immigrants, even if their entry was unlawful, are still persons within the jurisdiction of the state and thus protected by its laws and the Constitution.
Ah, so they used that same jurisdiction concept.
Exactly. And many legal scholars, including people like Judge James C. Ho, who was quite conservative, have argued that Plyler effectively settles the matter. Judge Ho's point is basically, if all 9 justices in Plyler agreed that undocumented immigrants are subject to the jurisdiction for equal protection purposes, then surely their children born here must also be subject to the jurisdiction for citizenship purposes under the very same amendment.
That seems like a pretty strong argument based on precedent.
It's considered a very strong argument by most mainstream legal scholars. The overwhelming legal consensus is that Wong Kim Ark, especially when read alongside Plyler, means that children born in the U.S. to undocumented parents are indeed U.S. citizens under the 14th Amendment.
Okay, so that legal understanding sets the stage perfectly for the intense political disputes we see today. What are the core arguments being made by those who, well, disagree with that interpretation?
Right. The political debate often centers on that phrase, subject to the jurisdiction thereof. Opponents of the current understanding argue it means more than just being physically present and subject to U.S. laws.
What do they argue it means instead?
Some argue it requires full or complete jurisdiction, implying political allegiance. They might look back at the original debates around the 14th Amendment. For instance, supporters of the current view point out that Senator Jacob M. Howard, who actually introduced the Citizenship Clause, and other key figures like Senator Lyman Trumbull, explicitly stated during the debates that they believe the clause would cover children born here to foreign parents, to aliens. President Andrew Johnson, who wasn't exactly a supporter of the amendment overall, even seemed to agree with that specific interpretation.
So the legislative history seems to support the broad view.
Proponents certainly argue it does. They'd say the framers intended a broad, clear rule to avoid the kind of status questions that plagued the country before the Civil War, especially regarding African Americans.
But people challenging this today read that history differently.
Yes. Some scholars, like Edward Erler associated with the Claremont Institute, argue that the Supreme Court in Wong Kim Ark actually misinterpreted jurisdiction. They contend it should mean something closer to exclusive allegiance, arguing that someone whose parents owe allegiance to another country isn't fully under U.S. jurisdiction in that sense.
Okay, so allegiance is the key for them.
Right. And they often argue that even if Wong Kim Ark was correct for children of lawfully admitted permanent residents like Wong's parents, that reasoning shouldn't extend to children whose parents entered or remained in the country unlawfully. They argue those parents haven't consented to U.S. jurisdiction in the same way.
What are the main counter-arguments to that specific view, the one trying to distinguish Wom-Kim-Ark?
Well, critics push back hard. People like Angela and Cheda point out the 14th Amendment was explicitly designed to grant citizenship broadly to all persons born here, precisely to include descendants of those previously considered outsiders, like enslaved people. Overruling Dred Scott was the goal.
Right, making it inclusive.
Exactly. And someone like John Yoo, another conservative legal scholar, has argued more recently that if the drafters had wanted to exclude children of aliens, whether legal or illegal, they knew how to write laws that did that. They could have used language specifying parentage, like in naturalization laws. He also points to the specific exclusion of Indians not taxed. He argues that showed the drafters knew how to carve out exceptions based on political allegiance, since tribes had a distinct sovereign status. The fact they didn't explicitly exclude children of non-citizen immigrants suggests they intended to include them.
It really highlights the challenge of interpreting historical intent in a modern context, doesn't it?
It absolutely does. How do you apply 1868 language and intent to 21st century realities of global migration and undocumented populations?
Yeah.
That's a central tension.
Beyond these sort of deep legal and historical arguments, there's a strong policy debate happening too. We hear terms thrown around like birth tourism or anchor babies. What are the concerns driving that?
Right, those terms are definitely part of the political discourse. Opposition to the current Jessonsali application has grown quite a bit over the last few decades. The core concern expressed by opponents is the belief that the current interpretation incentivizes people to come to the U.S. illegally or maybe even legally on temporary visas, specifically for the purpose of having a child here who will automatically be a U.S. citizen.
And the idea is that the child's citizenship then helps the parents.
That's the anchor baby concept, though it's a controversial and often criticized term. The argument is that having a U.S. citizen child might, down the line, make it easier for the parents to gain legal residency themselves, although it's actually a very long and uncertain process. A U.S. citizen child cannot petition for their parent until the child turns 21.
Okay. And birth tourism refers more to?
That usually refers to people, often wealthier, coming legally on tourist visas, specifically to give birth in a U.S. hospital, ensuring the child's U.S. citizenship before returning home.
Do we have any sense of the numbers involved? How many children are born in the U.S. to non-citizen parents, particularly undocumented parents?
Getting precise numbers is tricky, but studies have tried to estimate it. The Pew Hispanic Center did an analysis suggesting that back in 2008, about 8% of all births in the U.S., which was around 340,000 babies, were to unauthorized immigrant parents.
8%.
And in 2009, they estimated there were about 4 million U.S.-born children under 18 who had at least one unauthorized immigrant parent living in the U.S. The Center for Immigration Studies, which advocates for lower immigration, put out estimates around 2010 suggesting maybe 300,000 to 400,000 children were being born annually to undocumented immigrants at that time.
So significant numbers, which obviously fuels the policy debate. Have there been actual attempts to change the law through Congress?
Oh, yes. Numerous attempts. Bills have been introduced pretty regularly since the mid-1990s. People like former Senator Harry Reid, actually, and former Representative Nathan Deal introduced legislation over the years. These bills typically aim to redefine subject to the jurisdiction legislatively. They propose that a child born in the U.S. would not be subject to the jurisdiction unless at least one parent was a U.S. citizen or a lawful permanent resident, green card holder.
But none of those bills ever passed.
No, none have ever passed Congress. The legislative route has consistently failed, likely due to both political divisions and, frankly, serious doubts about whether Congress can actually change the meaning of a constitutional amendment through a simple statute.
Right, which leads to the idea of a constitutional amendment. Has that been seriously proposed?
It has been proposed by some legislators, yes. But amending the Constitution is, as you know, an extremely high bar. No such amendment has ever been approved by the necessary two-thirds vote in both houses of Congress to even send it to the states for ratification.
So legislation failed. Amendment is a long shot. That seems to leave executive action, which we've seen recently.
Exactly. Frustration with the legislative process led the Trump administration to explore executive options. In January 2020, they implemented stricter rules, making it harder for pregnant foreign women suspected of birth tourism to get tourist visas.
Okay.
Then, much more significantly, upon taking office in 2025, President Trump issued a major executive order. It instructed the entire federal government to stop recognizing Jessonsali birthright citizenship for children born in the U.S. to non-citizen parents.
Just stop recognizing it. Based on an executive order.
Yes, the order asserted that such children are not subject to the jurisdiction under the administration's interpretation of the 14th Amendment. And importantly, it aimed to deny citizenship not just to children of undocumented immigrants, but also to children of parents who are here perfectly legally, but on temporary non-immigrant visas, like students or temporary workers.
That sounds like a direct challenge to Wong Kim Ark and the long-standing interpretation. How was that received legally?
It was met with immediate and widespread legal challenges. Literally, lawsuits were filed almost instantly. 22 states, plus the ACLU and other groups, sued, arguing the order was a clear violation of the 14th Amendment.
And the courts.
Multiple federal judges across the country quickly issued preliminary injunctions, blocking the order's enforcement. They used strong language, calling the order things like blatantly unconstitutional and contrary to over a century of precedent.
So lower courts blocked it, but then the Supreme Court got involved recently, right, in that Trump v. Kasai case.
They did, just this past June 27th, 2025. But the ruling was perhaps not what some expected. It was more procedural. The Supreme Court ruled in Trump v. Kasai that while federal courts could grant relief to the specific plaintiffs who had standing to sue and could show harm, those lower courts could not issue universal, nationwide injunctions blocking the entire order's implementation everywhere, for everyone.
So they didn't rule on whether the order itself was constitutional?
Exactly. That's the crucial point. The Supreme Court did not decide the merits. They didn't say if the executive order's interpretation of the 14th Amendment was right or wrong. They only addressed the scope of the lower court's power to block it.
So the underlying constitutional question is still technically open at the Supreme Court level?
Technically, yes.
Yeah.
And that ruling immediately prompted immigrant rights groups to file new class action lawsuits that very same day, aiming to get relief for larger groups of people potentially affected. So the legal battle is very much ongoing.
And where does public opinion seem to stand on this right now?
It remains pretty divided, as you might expect. An Associated Press poll from January 2025, just before the executive order, found that a slim majority, 51% of Americans, actually opposed making changes to birthright citizenship, as currently understood. But obviously, there's still very strong support for change among a large segment of the population.
This whole discussion, especially the complexities at the border, reminds me of those surprising real-world scenarios, like the border babies situation between the U.S. and Canada.
Right. That's a fascinating example of how geography and law intersect in unexpected ways. You have many Canadians living very close to the U.S. border. Sometimes Canadian mothers end up giving birth in U.S. hospitals, maybe because it's closer in an emergency or for specialized care.
And because they're born on U.S. soil.
They are automatically U.S. citizens under the 14th Amendment, according to Wong Kim Ark, even if they go back to Canada the next day and live their entire lives there.
So they might not even realize they're U.S. citizens for years.
Exactly. Some have been called lost Canadians in a way because they discover their U.S. citizenship much later in life, perhaps when applying for a passport or dealing with other paperwork.
And that can have real consequences, right? Like taxes.
Yes, that's a big one. The U.S. is unusual in that it taxes its citizens based on citizenship, not residency. So these individuals who discover they're U.S. citizens might suddenly find themselves owing U.S. taxes, even though they've never lived or worked in the U.S. It creates real complexities.
Just shows how a principle like birthright citizenship can ripple out in ways you might never expect.
Wow, what a journey we've taken. From English common law centuries ago, through the really defining, often painful moments of the post-Civil War era that fundamentally reshaped who belongs in America, all the way to these incredibly intense legal and political battles playing out right now, even reaching the Supreme Court. Birthright citizenship, it really is a cornerstone of American identity, isn't it? But one that's constantly being, well, examined and re-examined.
It really is. And what's truly compelling, I think, is how a principle that was established so long ago, based on that ancient and fundamental rule, continues to evolve and face such profound challenges today. It forces us to confront these really big questions. How do we balance historical legal interpretations like Wong Kim Ark with modern societal realities, migration patterns, and, frankly, intense political pressures, especially when it comes to something as fundamental as who gets to be a citizen who belongs?
This deep dive really underscores how dynamic our legal framework can be, how it's constantly being interpreted, contested, and sometimes adapted, or struggles to adapt in the face of new circumstances.
So maybe something for you, the listener, to reflect on as you go about your day. How do these foundational principles, things we might take for granted, continue to be debated and reinterpreted through new lenses and modern challenges? And how do those reinterpretations, whether through courts or executive actions or public debate, actually impact individual